This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about estate planning. So if you've got issues in the family, maybe you've got land, you've got assets, and you wonder what would happen to them when you pass away. What do you need to have? Do you need to have a will? Maybe you're on the other side. You're a family member and you have concerns that mom or dad has land or assets and they haven't made a will. What do you need to be thinking about? Do you have any rights to their assets? Tonight, call in your questions, the 31 Law Call number 256-536-0077. You can call in or you can text to that same number and we will have some of your text questions. You can also email questions. You send them to lawcall@waytv.com. And when we get to a show that's on point, we'll have some of those questions. And we have some of your email questions tonight. Will Leake is here from Timberlake, Leake & Brooks. Good to have you here.
All right, Sharon, happy to be here. We're talking about wills and estates. You know, I think there was a blurb about 1 in 6 Alabamians is over the age of 65. There's a saying about death and taxes may affect us all, and so
we're all going to get there.
We're going to talk about that. So you got a question about wills, estates, trust. Do you have a living will? What happens if you go to the hospital and you need someone to make decisions for you? Do you have anything set for that? So be brave. We've had a lot of participation the last few weeks. I've been up here thinking about calling in. Give us a shout tonight. Let us know. Do you have a question about a will, estate, trust, power of attorney? You know, any of that stuff. We have an excellent guest. We're going to introduce him in a little bit. He knows all this stuff, Sharon.
Glad to have him here too. So before we get started, while we lock in some of these questions for you, we've got tonight's You Make the Law Call video. Can't be sure if this driver is just not paying attention. Maybe they had their cruise control on, because when somebody pulls in front of them, they just lose it. Okay, when you're facing something like that.
Right, Sharon, so car's going down the road, everything's good. Car into the right lane, merges over to the left, no issues there. Maybe they got a blinker, maybe they don't, but the driver in the white car got plenty of time. They've either got their head down, they're in their phone, they're daydreaming, something's up. Because you have a duty to keep a proper lookout of the vehicles in front of you. You have a duty to keep a safe distance. Clearly, white car failed this duty, and I think if upon further either examination of the phone, the black box in the vehicle is going to show cruise control.
Yeah.
They don't even check up. Swerved in the lane, swerved into the right two lanes, and cause a crash. I mean, they're liable, civilly. If they're on drugs or acting wanton, there could be criminal charges, just not paying attention. But what caused that, and further forensic evaluation will need to be done. The police officers go in there, do an evaluation. If there, God forbid, there's a death or serious bodily injury, they go in and look at phone data, look at black box data. Our firm, we evaluate and look at these claims, every week. And Sharon, you look at those things, determine what happened, and they may say, hey, somebody pulled in front of me. Well, it's clear from that video that the negligence is on the driver of the white vehicle.
A lot of evidence out there now that you're able to get a hold of when you're working on this.
It is, and that was clear, and the other drivers have claims for property damage, injury, medical bills, pain and suffering, all those things. Hopefully nobody was injured, but clearly fault or liability in this case is with the driver of the white vehicle.
So tonight we're taking your calls and questions about estate planning. So wills and trust. Okay, this is an area that people don't understand well, and they oftentimes will try and do it themselves, which is not a good thing. We've got an excellent guest to walk us through the questions.
Well, people come to me and say, hey, I need a will or an estate, or I want to do a trust. I'll call somebody like Tracy Marion to come in and talk to those folks. And Tracy, first off, thank you for staying up with us on Law Call tonight.
Happy to be here.
So I know a little bit, and I can tell you what I know in probably less than 5 seconds. Unified credit, if you have an estate, and a lot of people out there sitting a lot of money and want to transmit that to their loved ones without paying a lot of it to the government. There are a number of tools. But if you have $12 or $13 million, that won't be taxed. And then if you were trying to give gifts to family members or friends, you can give up to $17,000 per year without going into unified credit.
Right.
Now, what does that mean, the unified credit versus the gifts? Now, if you spend over $17,000 per person, that eats into your unified credit, correct?
That's true, and it becomes taxable to the recipient. But I think one of the big things to think about is, number one, you really have to consider the estate overall of this person. What kind of assets do they have? Because when you start talking about these transfer taxes, remember there are a lot of ways to accomplish these transfers, and that's one of the things we'll be talking about tonight is the difference in wills and trust. We're also going to be talking about what happens when your loved one or you just don't have anything. You don't have a will, you don't have a trust in place, but when it comes to that sort of higher level estate planning, you really want to take advantage of some of the tools that you were mentioning, like the credit that you get each year up to $17,000, the $13.6 million per person right now that could transfer without any federal estate tax issues. There's some talk of that being lowered. As a matter of fact, there's a sunset on that right now that the first of 26, I believe that number gets dropped automatically back down to about $6 million. Still a lot of money, but for a married couple, that means over $12 million is going to become taxed, and that's at a federal estate tax level, which is going to be a lot higher than normal capital gains. So there's a lot to keep in mind. Fortunately, it's not terribly complicated, but as Sharon pointed out, oftentimes when you try to do it yourself, you can run into some problems pretty quickly.
And where it comes in with us, like we do a lot of nursing home abuse cases, and not only if the person didn't have a will or a personal representative, if the injured party, the elderly person is incapacitated, who can drive that particular case for them? And that comes into play. When you go into a nursing home, if you qualify for Medicaid, they'll pay for that, but you have to spend down that money properly. Yeah. And if you do it on your own, oftentimes it's recaptured and it depletes your assets, and then you qualify for Medicaid.
We've got callers waiting with questions. We've got Myrna on the line with a question from Elkmont, Alabama. Hi, Myrna. Thanks for calling. What's your question tonight?
My question is, if a person has power of attorney over a person and that person is not capable of making decisions on their health, what do I have to do? Can I just tell her she has to go someplace, or
so if you have power of attorney for we'll say your friend, and your friend is no longer making good decisions for herself, you question her ability to make decisions for herself. Is that right?
Right.
Okay.
That's
walk us through what to do with that.
That's a very good question. The joke about asking an attorney a question is that often the retort is, well, it depends. That is a very good question. In this case, it's going to depend on the language of the type of power of attorney that you have. There are two basic types of powers of attorney. One is mainly financial, the other is healthcare driven. So if the power of attorney in this instance is the healthcare version, that's a start in the right direction. The more detailed that document is, the better, because ultimately, when you go to interpret these things, you have to look at it from the eyes of not you or your friend. Unfortunately, a lot of times you look at that from the eye of a risk committee or the in-house lawyer for a hospital, because they're the ones who might ultimately be saying, hey, is this power of attorney really going to, does it give this person, you, for example, the power to do or speak for this other person the way she thinks it does? And that goes right back to one of those things we were just talking about. If you try to do that yourself, you might have language that's just too broad. So it really would come down to the language of the power of attorney that you have for your friend.
And for example, this power of attorney is a list, okay, you can buy, sell real property, invest in the stock market, you can, get money in and out of my checking account. I'll give Tracy all these powers listed in this power of attorney, and if it does not list making health care decisions for me if I'm incapacitated, you would not be able to do that.
I would not be able to do that. Right. That's correct.
And so traditionally we think power of attorney and also a living will or a health care directive. But basically a power of attorney, if you list all the powers, that can suffice as well, right?
It can. It typically does. What you really, again, want to watch out for there is everything's contextual. So you want to be as clear as you can. Think about it this way. When you're setting up your power of attorney, whether it's the financial or the health care, now is your time to speak for yourself later when you're not able to speak for yourself. God forbid you get into some type of accident or you have a medical condition. You want all that set out as clearly as possible, and you want to make sure that your loved ones, particularly the person that holds that power of attorney, you really want to make sure they know what you wanted in case there's maybe a little bit of ambiguity in that power of attorney. Again, that way the doctor or the healthcare staff will be much more likely to carry out the wishes that you wanted for yourself rather than having someone else make them for you.
You know, in that second case, let's say there's not a power of attorney, or the power of attorney is limited in its scope, does not allow for health-driven decisions. And so we're left with going to the courts, going to get a guardian or getting a conservator appointed over you. And that conservator, again, is not your buddy. It's not someone you chose. It's someone the court will appoint to make those decisions. And you know, if you do not have that advanced health care directive, a living will, if you will, or an all-encompassing power of attorney, then you got to go and put your family through the courts. And then does your desire or your wishes, are they followed at that point? So again, nobody wants to talk about it until they're sick. But you know, if you had a mom or dad, nobody knows what's going to happen and when. But you know, you get in an advanced age, if you don't have one of the will or any of these instruments in place, you know, go down, talk to an attorney like Tracy, and just see what your options are. Because people come in all the time to my office wanting to, you know, maintain an action. And without those tools in place, there's nobody to drive the litigation. And it takes us a while to get that set up. Evidence gets lost, it gets splashed around the sun and evaporates. Tracy, let me ask you this. So let's talk about the difference in a will and a trust. So I've got a will. It says, God forbid something happens, everything to wife and kids, and it's pretty clean. Mm-hmm. That will would have to be admitted to probate.
Correct. And
the court would make the determinations based on the will that I submitted.
Correct.
But let's say I wanted to avoid all that. And people talk about trusts, and okay, you avoid, one of the big things is you avoid probate.
Right.
And it follows along with what your wishes are without getting the courts involved. So I've opened up a trust. I can have benefits of that trust, and when something happens to me, trustee will hold it for my minor children until they're of age, that sort of thing.
Correct.
Who is there to make sure the trustee is doing what he or she is supposed to do? We talking about a person, a bank, a company? Well, how does that work?
A trustee can be any of those those entities you just listed. I think one of the first things we need to consider is the will does have to get probated. It's amazing to me how many people will come to me. Sharon and I were talking earlier, and these are sophisticated people. They'll come to me and say, well, you do wills and trusts and estate planning. I say, yes, I do. And they say, well, I have a will, so I'm fine. I won't have to go through the court process and all that. And I have to tell them, that's not true. The will does get probated. And so one of the things it's easy to miss if you don't live in this world, probate is a boring, expensive, time-consuming process. Not a lot happens, but it's going to take generally 9 to 15, maybe 18 months. Could take longer if you have a complex estate. You got a lot of property. You have property out of state. It can take longer, but it's going to take a court-ordered minimum, statutory minimum of 6 months, because you have to make sure all the creditors know that you've passed away. So this show's not quite long enough to go into the details of probate, but you want to avoid it if at all possible, because it is time-consuming and it is expensive. It typically costs about 3 to 4, maybe even 5% of your net assets in your probated estate. So one of the ways you can avoid having to go through that process is setting up a revocable or revocable living trust. It's pronounced both ways. I like to say revocable because it puts the point of it right there, which is it is revocable. That means if you have a revocable trust, you still have control over those assets. So if I say, okay, I'm going to have a revocable trust for my kids, I can list myself as trustee. I might list my friend Will as the successor trustee, because if something happens to me, that revocable trust immediately becomes irrevocable, but Will, as the successor trustee, could still work on getting those assets distributed. And I think the final point there is, just like with the powers of attorney that we were just talking about, this is your time. When you create that will and trust, this is your time to say, I want my kids to get it, but not before they're 23 or 25.
Right.
They can only use it to go to college until they're 25. You get to determine that even now, so that you make sure it gets carried out the way you want later.
And the trustee is charged with making sure all those those pre-issues that you have defined are met.
Correct.
And the beneficiary, let's say I go off the rails as a trustee. The beneficiaries can then maintain an action and say, look, Will League didn't follow the contract exactly as Tracy wrote it, so therefore I have violated my fiduciary duty and I'm subject to the court sanction as well, correct?
That's correct.
Okay.
Correct.
All
That's
right.
right.
They're telling us take a break. We're going to take a break and be right back. We've got more questions to get to. Thank you for all your questions. Hold on if you're on the phone. We'll be right back.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're talking about estate planning. So things like wills, powers of attorney, advanced directives. So we've got callers waiting, but we've got to introduce. We've got with us Will League, who's from Timberlake, League & Brooks. And we've also got Tracy Marion, who is an estate planning attorney and is answering all your questions for you tonight. What are the basic documents everybody needs to have? Everybody needs to have.
So, in my opinion, just about everybody's going to need at least a will and a revocable living trust. You'll also need those powers of attorney we were just talking about, the healthcare power of attorney, and a separate financial or durable power of attorney. Some people say, well, what's the point of the will and the trust that I have? Again, specificity is your friend. You want to make sure that those powers of attorney really set out in detail what you want, how you want it done. If you have minor children, you'll want a kids protection plan. God forbid you and your spouse are on a date night, something happens to both of you. Who's going to take care of the kids? Who knows that the kids are there with a babysitter? So having a kids protection plan that is layered. You've got maybe the next door neighbor would take care of the kids for the first 2 days until your sister can come in from Chicago. You know, you kind of have to think about how those things are actually going to progress. And no one likes talking about this. That's part of the problem that I run into is no one likes to sit down and talk about their immortality, the bad things that can happen in life.
Right.
But it's inevitable, like you said, it's death and taxes. And so here we're talking about both, really.
Right. And I always get a call if somebody's about to get on a plane. Hey, we hadn't done this. Can you do a will real quick?
Right.
And wait, I'll do a simple one, but you know, just to get you back, and let's get you to a real estate attorney.
That's right.
Because again, that's something you want. That's something you want to patch up, but nobody wants to think about it until both folks are getting on a plane or something like that.
We had a quick caller asking, so she lives in Tennessee and her son's in Alabama. Does it matter what state she does the will in? Trying to make it easy for her son. Does she have a choice?
She really doesn't have a choice. If she's a resident of Tennessee and that's where her property is, she'll need to go through with the estates, the state of Tennessee's procedures, which are going to be set out in the statute. Now she can address property that's held in a different state, but she'll be going through Tennessee on that one.
Okay. We've got caller Howie with a question from Huntsville. Hi, Howie. Thanks for waiting. What's your question tonight? Do we still
Yeah, I own several rental houses that I sold, and a couple of them I took back mortgages. I was told that if I put in one of these trusts, that if there was a problem, I had to go to court over them, that I would not be able to represent, even as a trustee, I would have to hire a lawyer to represent my interest in court. So I haven't done that. My question is, in my will, I've got 3 children who are going to, the administrator's supposed to split the proceeds if I die, as those mortgages are paid equally between my 3 children. One of those, if there's a problem, if I die, and the administrator has to go to court to enforce any of those mortgages, will he have to hire a lawyer, or can he handle it himself?
Well, it sounds like it's going to be complicated enough he's going to want a lawyer.
Howie, do you have an LLC or a corporation?
No.
Okay, so If you have a corporation, how is that different than just an individual?
Yeah, so in this case, if it's just through the will, I think it is going to be complicated. I'd really have to get a little bit more into the facts. But if you set up an ownership structure for your real estate through an LLC or an S corp, that entity would absolutely have to have an attorney represent them in court. One of the maybe downsides, because a company can't represent itself in that regard. However, it can really help protect with some liability too, because what we're talking about with estate planning is really for your financial health. The LLC structure or an S corp structure would protect you on the just the liability and the liability end of things during life. So you can have, for example, the LLC hold property, and the LLC could be you could have the LLC set up through your trust so that the property still will transfer to your kids. It might just be through the ownership of the LLC interest, which then in turn own the real estate. So there's ways to do that, Howie, but it does require a little bit of advanced planning. Good for you, by the way, to have those kind of assets for your children. That's great.
We got a text question. Somebody's talking about, my father has a will dividing up his assets among the kids. I understand if he has to go into long-term care, these would have to be sold to pay for it before Medicaid kicks in. Is there a way to avoid that short of giving everything to the kids now?
You can, one of the hardest things to do, I think, is make the decision of when you need to get active on doing some of these things. So for Medicaid, they're generally going to look back 5 years from the time you start the Medicaid application process. So the time to do the kind of estate planning that you need is 5 years and 1 day before something happens to you. And none of us know when that's going to happen. So is there a way to do that? By going ahead and moving some of those properties now, or assets of any nature, you start that clock ticking a little bit, and so hopefully you get those 5 years to pass. But that's right, they'll come back and look, and they'll start selling those properties unless they've been outside for 5 years.
And what that looks like if you do not have, that in place, or the recapture period. Let's say it's a year from now, mom's got to go into the nursing home.
Yeah.
And she has, let's say, $500,000. Well, you're inside that 5 years. So she will not qualify. She has too much money to qualify for Medicaid. She's got $500,000, whether it be her house, cash, whatever it is. And so let's say nursing home is $22,000 a month.
Ooh, yeah.
They will have to spend $22,000 per month until she gets below the threshold to qualify for Medicaid. And it's imperative that what Tracy's talking about is the planning must be done 5 years and a day, or hopefully longer, so you can then spend down those assets in accordance with mom's wishes, as opposed to giving it all to the health care provider or the nursing home prior to qualifying for Medicaid. So it has disastrous consequences, and that is something that every family needs to look at. If you feel that you need or may need long-term care, some people have these insurance policies to provide care in their elder years. But if you don't have that and Medicaid is an option, please sit down with somebody, because your family does not get the benefit, nor do you get the benefit of all that money saved if you fail to prepare, especially when it comes to Medicaid.
We're going to take a break. Be right back answering more of your questions about wills and estate planning. If you didn't get your questions answered tonight, here's how to get in touch with Tracy Marion with Tracy Marion PC in Huntsville, 256-798-0983. You can also check out tracyandtara.com. If you'd like to speak with Will League with Timberlake League and Brooks, they are personal injury attorneys, so everything from car accidents to nursing home negligence. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Doviet, family law attorney, children, child custody, divorce. 256-539-7337, SharonFamilyLaw.com.
Tracy,
thank you so much for coming up.
Absolutely, yeah.
Thank you so much.
Good questions, good answers.